Uh, a very good morning, everyone. Welcome to this day two of the webinar on water pricing in India. We will be having the third session on water regulatory authorities' recent trend. We have with us our guest faculty, Dr. S.K. Sarkar. I will briefly introduce him and then I will hand it over to him. Dr. S.K. Sarkar is the Distinguished Fellow and Advisor, Water Resources Division at the Energy and Resources Institute, New Delhi. He is a doctorate in economics from the State University of New York. He is an retired IAS officer, and he is a former secretary to the Government of India in the Ministry of Water Resources. He was also the secretary of Department of Personnel and Training during 2013 and 14. He served other ministries, including Finance Ministry, and worked in various capacities with the government of West Bengal. He also worked as member secretary, West Bengal Pollution Control Board under State Environment Department during 2003 to 2005 and formulated policies on plastic waste management. He also worked as consultant with the Asian Development Bank and the World Bank Public-Private Infrastructure Advisory Facility. He headed the Natural Resources and Climate Program, including water resources sector, during 2014 and 2023 at TERI. From 1998 till 2003, he worked as Senior Fellow TERI in Infrastructure, including Water Resources Division, and during 2005 to 2007 as Director, Division of Regulatory Studies and Governance in TERI. He has got several publications to his credit and has authored and edited books on infrastructure issues and has presented a number of important papers in several conferences. He taught a course on public policy in the Kabul University in Afghanistan in 2007 and also at TERI School of Advanced Studies, formerly known as TERI University. With this, I formally welcome Dr. S.K. Sarkar, sir, to deliver today's session on water regulatory authorities' recent trend. Thank you. Thank you very much.
Good morning, Mr. Chaitanya. And first of all, let me thank you very much for inviting me for this kind of important session. The subject is very close to my heart, and we'll be able to discuss some of the thoughts I have on the subject.
It is our pleasure, sir. We also have with us D.S. Chaska, sir, head of National Water Academy, Chief Engineer and Head of National Water Academy with us. Thank you,
Good morning, sir. Good morning, sir. And it's our privilege to have you today to deliver a session on such an important topic, sir. And you was heading our ministry, and we still remember those days under your guidance and leadership. National Water Academy at that time we also conducted numerous training programs, and it is really a privilege for us to have you today. Thank you so much, sir, and welcome.
Thank you very much. Thank you. So I have prepared a few slides so that we can go through it, and then we will have some discussion at the end of the presentation. Next. So what I propose that I'll give a little background on the subject, and then I'll go to the Water Resources Regulatory Authority framework, which is now we have been seeing in India. And then I'll just pick one environmental issues, particularly the water conservation, how these are being managed by the regulated by the. Is it visible now?
Yes, sir, it is visible. Sir, we can also go in full screen mode so that it will be
okay.
Better.
Is it okay now?
Yeah, it is okay.
Okay. And then I'll go a little bit on the water conservation, how the water regulators are addressing this issue. And then based on the discussion, I will try to place before you a format, a kind of framework which we should have in India in the future years. As you know that the Water Resources Regulatory Authority's laws, they had a very in the distant past, over many decades, there are remarkable changes across the world, particularly the water sector, especially with regard to legal side, policy side, and administrative spheres. As you know that in most of the infrastructure sector, particularly in Indian context, it was a state-central kind of approach the government made. And similarly, we have seen this approach in the Indian context in the water sector as well. And in other infrastructure sector like telecom, like electricity, there is a tendency, the regulatory tendency to go towards a market-centered paradigm approach. And same concept is being developed in the water sector as well. In the water sector, including many countries, including India, the emphasis is the institutional reforms, the demand responsive approach, and the community participation in water management, because they are the ultimate users of the water resources. And the background show in other countries and including India that the independent water regulatory authority should be set up, which is a little distance from the government, and government plays the role of a facilitator. So these are the kind of approach which many countries, including India, has thought, and they are trying to move forward. The role of international financial institutions towards this concept, particularly in the water sector, are based on a couple of principles they try to push. For example, if you look at our electricity sector, the first World Bank project on this subject, the restructuring and the regulatory setup, was introduced in 1995 or 6 in Odisha, and thereafter it was adopted and in a big way at the central level and in the other states. So the idea was that the water should be treated as a commodity, and the full recovery of cost should be the basic principle which the international financial institutions they try to move forward. Accordingly, they suggested that they are of the view that the role of the state should be redefined and restructuring should be made, and this will result in the increasing participation of private sector and, of course, decentralization of the governance. So these are the principles which the international financial institutions they followed even in Indian context, which I will discuss a little later. If we look at the water sector reforms, I think it is better to know also a little bit in the background so that we can discuss a little currently at the end. In 1985, the Ministry of Water Resources was created from the Irrigation Department of Government of India. Earlier, there was no Ministry of Water Resources, and the Irrigation Department was the main policy-making department in Government of India. In 1987, the first national water policy treated water as a basic human need and a precious national asset. So this is the first principle the National Water Policy 1987 adopted. 2002 National Water Policy talks of environmental sustainability. This is the first time that in the water sector, this kind of approach should be adopted. That was the direction given by National Water Policy 2002. In 2012, even after 10 years, the National Water Policy 2012 talks about cost recovery, talks about tariff setting principle, and of course the regulator, water regulator, to do this kind of assignment. Many states formulated state water policies along with enactment of participatory irrigation bill, because as you know that the irrigation consumes the 75% of the water used. So irrigation was the main important area in the state. So along with these policies, participatory irrigation bill was also introduced in many states. Maharashtra is the pioneering state to enact this independent regulatory authority in 2005, and the 11th five-year plan, that means 2007 to 2012, working group on water governance, they suggested the Water Resources Regulatory Authority. This is the first time from the Planning Commission we found this kind of approach. Some states agreed to recover the full O&M cost. For example, the Gujarat, Maharashtra, Andhra Pradesh, Madhya Pradesh, Odisha, Rajasthan, Jharkhand. And of course, subsequent reforms in the water at the central level as well as by the state level at various segments we have seen, and that resulted in the current dispensation. Now this I have listed a few enactments by various states. The enactments are of three types. One is that the act was approved by the legislature in the state. Sometimes it is by ordinance by the state. Sometimes it is by the notification of the states. One thing I must say before I discuss, that all the regulatory act in the water sector does not mean that the regulators are in position or working. For example, Maharashtra is the first state which enacted the Act 2005 Act and positioned regulator thereafter. Of course, this act was amended in 2011 and 2018, but it is the first state which have a pioneering approach in Water Resources Regulatory Authority. Following that approach, the Arunachal Pradesh Act 2006, which is almost a duplicate, is a replication of the Maharashtra Act, they they enacted the act, but unfortunately, there is no water regulator till now. UP Water Management Regulatory Commissions Act 2008. UP has an interesting example that the World Bank initially funded in water sector, particularly in the irrigation sector, where they wanted the pricing of the irrigation water, and thereafter they took project for restructuring of the water sector, and they pushed the government to enact this act, Regulatory Commissions Act in the state. In 2008, they enacted the act. 2014 also they revised that act, but unfortunately there is no water regulator in UP. This is very interesting example that although there is an act, but positioning of regulator is a very delaying efforts. Andhra Pradesh Water Resources Regulatory Commission Acts 2009, it is only an advisory in nature and there is no regulator today. J&K Water Resources Regulation and Management Act 2010 was enacted. Fortunately, there is a regulator, but the regulatory members, they are not being positioned regularly. There is a long delay, but there is a regulator. Kerala Water Resources Regulatory Authority, there is no regulator as such. Gujarat 2012, they issued a notification of the Water Resources Regulatory Act, but there is no regulator, water regulator. Punjab Water Resources Management and Regulation Act 2020, there is a regulator which is working. Haryana Water Resources Conservation Regulation and Management Authority Act 2020, there is a regulator. So out of all the examples, there are only 4 cases we can say that there is a regulator which is in position and is working: Maharashtra, J&K, Punjab and Haryana. There are other states where the acts are passed, but there are no regulators. Take the example of Telangana. In 2009, they have passed the enactment. In Uttarakhand, 2013, they passed the enactment, but there is no regulator. So that means that the urgency of the state is not very much clear. But many of the states, the groundwater authority bill, which the central government is pushing, they have done. There are 21 states where the model bill, regular groundwater bill was taken. But this approach of Water Resources Regulatory Act and positioning regulator is missing in those states. As I said earlier, that the international financial institutions like World Bank, they tried to restructure the water sector and the position water regulator in 2 states. One is MP and is UP. UP, they have enacted the act, as I said earlier, but in the MP, it did not see the light of the day. The role of the central government was partial, as I said earlier, the role of the central government was very clear, that the Erstwhile Planning Commission midterm appraisal into a 10th 5-year plan, they felt that the Maharashtra water regulator should be duplicated in the other states. And there is of course, further there is a policy push through National Water Policy 2012 for positioning water regulator. Like the central government, the state government also, many state government also have formulated state water policies for positioning water regulator, like Andhra Pradesh in 2008, Maharashtra 2003, UP 1999, Odisha 2007, West Bengal 2011. But it doesn't mean that the water regulators are there in all these states. But the prime concept of having a water state water policies is there in many states, and probably subsequently there will be it is to be followed by the regulator. That we have to see. Now let me look at the structure of the regulation enacted by various states and how does it look like. For example, the state legislature drafted and they approved the framework in most of the states, except in Gujarat and Kerala. Most of the states, the state legislature passed it. Gujarat, of course, through notification in 2012, and Kerala through ordinance. So basically, but in general, the state legislature is the competent authority to pass an act and for its subsequent adoption in the states. Water tariff, as I said earlier, that one of the principles of the independent regulation in infrastructure sector, which we have seen in many other subsectors like electricity, telecom, oil and gas, other sectors, on the tariff principle, that the regulators and the tariff should go together. And the principle with cost recovery and reducing subsidy is one of the principles of the regulatory framework in general. For example, we have seen in Maharashtra recovery of O&M cost, in UP recovery of O&M cost and depreciation of subsidies. In Haryana and Punjab, they have not given that principle, and the full recovery of cost, which is the fundamental principle of any independent regulation in infrastructure, is yet to be adopted in the current disposition in India. It's very interesting to see that the Maharashtra regulator is also mandated to fix criteria for trading of water entitlements. Here, water entitlements is in relation to a basin kind of concept, which Maharashtra is the first state which talks about that. But there is a view that the unmonitored trading of water rights probably will create some kind of a loss of control at the local level, which I do not agree. But there is a view that it might the trading of water entitlements should be monitored, and in fact this is not there in the Maharashtra, although Maharashtra regulator fixed criteria for trading of entitlements. Environmental concerns is one of the important objectives of the water regulator. So, for example, the sustainable management of state water resources is the objective, being the objective of legislation. For example, in Maharashtra, Arunachal, J&K, Punjab, Haryana, the legislation promotes sound water conservation. So it is very important subject, and in several states, the regulator is responsible for promoting efficient use of water and minimizing wastage of water. So this is because water resources are finite, so one has to see that water is conserved and saved. However, unfortunately, most regulatory laws are silent on how to do it. That is a part. That is an important part. For example, in In Punjab, they say that water conservation is there, but how they will implement it, that's an issue. In Andhra and Kerala, the regulators they set standards and monitor them. So that is also an advanced thoughts in those legislation. Another very important thing we have to remember that the original idea of creating the water regulator, that it is a little away from the government. And if it is away from the government, there should be some kind of relationship between government as a facilitator and the regulator and the water WRRA as the regulator in the water sector. But what happened in the enactment in laws, some of the laws, they have given the predominance of the bureaucrats. For example, in Maharashtra, the additional chief secretary rank officer should be the chairman. In Haryana, also the additional chief secretary or chief secretary rank officer is the chairman of the regulator. In Punjab, although they have not mentioned it, but they have positioned in reality an officer who was the erstwhile chief secretary of the state. Of course, there are expertise there in the authority, but it is dominated by the bureaucrats while forming the laws. Some laws provide reappointment for a second term, but in chairman they are not eligible for further employment in government for 2 years. So this is because their conflict of interest. So this 2 years gap has been kept. Should have been there. In UP, it is there, but the government can relax this with the permission of the government. The government can relax this. So that means that there is a predominance bureaucratic tendency in the authority selection and the authority framework. The running the authorities affair, you require a fund. So there is the fund mechanism. There is a fund for regulator which is established in many states. The funds should consist of grants from government, loans from government, fees, charges, fine used by the regulatory authority, the government. Should be part of that fund. In Haryana, it is there, but also it's very interesting that the CSR fund, the private sector CSR fund can be given or can be taken by the authority as a fund supplement. This is the first time in regulatory laws we have this. Some kind of conflict of interest comes with this kind of approach in Haryana context. The funds are to be audited by accountant general, that is there. In Maharashtra we have seen, in Haryana we have seen, but somehow in Punjab it does not exist. But in general, if there is a fund of the regulator for scrutiny, for scrutiny by an independent authority, is a general principle, and that has been adopted by many regulators in water sector. As I said, that the main concept of regulator in the water sector, that the states and the regulator, there should be slight distance, but there has to be some kind of relationship. What is relationship? One of the ways the relationship is that there should be a policy direction. In Maharashtra, it is there. It is there in the electricity sector, it is there in the telecom sector, it is there in the oil and gas sector. And that policy direction by the government to the regulator should be in the public interest. And that has to be open, and the regulator has to abide by it. Unfortunately, in Haryana and Punjab, there is no such provision of policy direction by the government. So this is a missing part in the framework, and especially in these two states. One of the objectives of the regulatory framework that they should be transparent. Whatever they decide through regulation, through mandatory provision, or through recommendatory provision, or through advisory provision, it has to be the public, the expertise, the public should know, the stakeholders should know, and if they have any grievances, if they have any say, they should place before the regulator. So in Maharashtra, there is a prior publication of rules prepared by regulator to obtain the opinion from the stakeholder. For example, in the tariff regulation, there is a consultation is required. In Punjab, there is a regulation for consultation process. In Haryana, no such provision. For example, even for the water tariff in Haryana, there is no concept of consultation with the stakeholders in that state in the regulatory framework. As you know that in water sector, when you are talking about a regulator, we are talking about there is no model regulator, model framework available in the country, which is at the central level. At the central level, for example, in the electricity sector, there is a model state regulatory commission. Of course, one can say that water is a state subject. So how can the state, how can the center enact the legislation? But there are provisions in the constitution which can be used for making a model central legislation on water sector regulating. But the planning commission, the erstwhile planning commission, did some study, and they come out with certain a model where the water tariff and the water sector privatization is one of the objectives they have suggested, which is missing in many of the regulatory framework in the country. The social objective should be there: equity, fairness, justice in provisioning of water services. Of course, the model did not deal with how the objective be made, and of course, it talks about environmental sustainability. The water regulatory framework, which the Planning Commission have suggested through the working group on water governance, they have suggested a number of institutional framework. One is a State Water Resources Regulatory Development Council as political mandate. Why? Normally the council should be chaired by the Chief Minister. This kind of council has been adopted in Maharashtra. Then there is a Water Resource Department or Valley Development Corporation as an institution in this framework, because the River Basin Agency has been conceptualized in Maharashtra setup. So they also suggested that, and this framework suggested that the water resource department should be the next level after the Supreme Council. Then there is a state water independent expert authority for regulation and monitoring, and they again went down for decentralization purpose. For example, they suggested a state level, the Supreme Council is there. Then basin level, there should be some expert body, sub-basin level, local level. And also it suggested that the regulator should be an expert body. It should be independent of government and more transparency and more consultation. So this is the some kind of framework the working group of water governance has suggested. Unfortunately, it is not being adopted by any state till now. For example, in Haryana, there is no integrated state water framework or council. Because in Haryana, the regulator has been mandated to prepare a state water security plan. Whereas in the planning commission setup, there should be another body. In Punjab, this council exists, but they have an advisory committee headed by regulatory chairman and prepares the interstate water program council headed by the not PM, headed by the CM, Chief Minister. There is a mistake here. Now to say a little brief on what these regulators have been talking about, particularly in those three states where regulators are in position. In Maharashtra, which is the oldest water regulator we are having, they determine the criteria for distribution of entitlement by River Basin Agency. They enforce decisions. They determine priority for equitable distribution of water available at the water resource project. Water tariff system is a mandatory provision, and they should fix criteria for water charges. Interstate water resource apportionment on river system. This is the first regulator where they are talking about interstate water resource or river system. Then the criteria on monitoring issuance of entitlements, but or trading also, trading of entitlement they are talking. So this is some of the, there are 20 odd functions. I have just kept taken a few for just flavor of them. In Punjab, they talk about Punjab, the tariff in the preamble, Punjab Water Regulatory Authority, the preamble of the Act does not talk about tariff, mandating the tariff. Whereas in Maharashtra and Haryana they mandate, but in Punjab it is missing. What they say, they ensure development, management and conservation of water resources of states in accordance with the state plan. Or issue direction in restrictions of utilization of groundwater, optimal use, surface water, industrial use, efficient use, etc. To me, the Punjab Regulatory Authority is more inclined to groundwater, because Punjab, the groundwater is a big problem, big issue. So they are more inclined towards groundwater issue. Issue advisories to government for increasing water use efficiency in agricultural sectors. There is no ban on extraction of, there is no ban. Groundwater for drinking and domestic purpose, no ban. Industry, there is a ban. Issue tariff order specifying charges to be imposed on entities. For example, for supplying by entities for drinking and domestic as per government policy. So they are looking for the government policy on those sectors, sectoral allocation, which we have seen in the Maharashtra also. Maharashtra also has to see the sectoral allocation made by the government. The highest decision-making body has to give indication on the sectoral allocation of water. With the approval of government fixed charges, extraction of groundwater, here again the government approval is required rather than giving the suggestion to the government. In Haryana, Haryana is very interesting that they recommend to the government for tariff for all uses of surface water. They don't determine, but they recommend. They recommend to the government. Prepare a state groundwater and surface water plan as per the district planning committee. They encourage rainwater harvesting, groundwater conservation, recycling and reuse of water for notable, and issue advisories to the government. Water, for example, one example, I just wanted to see how the environmental issue like water conservation has been actually performed by two regulators. One is Maharashtra and one is Punjab. In Maharashtra, in 2018-20 tariff order, the water incentive and disincentive has been enumerated. For example, on adopting, if any user adopts drip and sprinkler, then the applicable levy is only 70%, not for the 100%. But if it is an unmetered use of water, the tariff is 1.5 times the floor rate per individual. See, 1.5 times, that means it is a disincentive if you don't use the meter. For recycled or treated wastewater, 60% applicable rate of water is reused in irrigation. So that means it is reduced. For industrial use, if your demand is reduced by 25%, your rate is water rate is 75%. So there is this very interesting in domestic sector, in industrial sector, in irrigation sector. In all sectors there is a incentive or disincentive provisions are there. In Punjab, there is a water conservation. There is an order direction issued on 27 January 2023. The users to pay volumetric extraction charges. There is a water conservation credit from the regulator. Conservation with regulators' approval. Users may opt to implement water conservation within unit or outside the jurisdiction. So there is a flexibility given to the industries. Rebate on groundwater extraction charges. For example, if a unit situated, industrial unit situated in orange zone of the groundwater assessment blocks and extracts 3 lakhs cubic meter per year, it can earn a maximum water conservation credit to the tune of 16 lakhs per annum. And to that extent, the groundwater extraction charges are reduced. So this is one example how the groundwater conservation are implemented in Punjab. Now, what we have seen so far is that there is no uniform law in India which the state can look for while enacting the act. As I said, there are 4 regulators are working as on today. Many the states are the water framework is there, but there is no regulator in position. So recommended, what I feel that the regulatory framework should be the preamble of the regulatory framework should talk about ensuring orderly growth of water sector. So water sector as a whole, they should look into. They should promote the environmental issues such as conservation of water, rationalize tariff for water supply. It could be wholesale, it could be retail, it could be others, entitlements. They develop transparent policies towards subsidies. Subsidy are being given in the water sector, so transparent policies should be subsidy, and they promote efficient and environmental benign policy. So this should be the preamble of the framework which the state may look for. The constitution of the regulatory authority, which I think is that this water regulatory authority be selected through a transparent process, and it should not be biased toward the bureaucratic framework. The qualification and disqualification criteria be laid down. The regulatory members should have fixed and staggered tenure. On a stated ground, members can be removed. The process must be transparent, and it should not be a mostly bureaucratic committee. The function, what should be the function of this regulatory body? As we have seen that many states have adopted a different framework because there is no model legislative framework. One function should be that the core function, recommendatory function, and the advisory function should be there. Core function may this tariff setting could be one of the function. So what could be the core function, what could be the recommended function, what could be the advisory function, that should be discussed and adopted, but it should be there. They lay down quality of service to be provided by service providers. So the service provider should act as a utility, and the quality of service should be provided, should be enumerated, and should be implemented. Adjudication of dispute. If there are disputes between the stakeholders and the service provider, then adjudication of disputes should be given. That authority should be given to the regulator. Promote competition, efficiency, economy in the activities of supply of water. This must be there. Otherwise, the water sector, the finite water resources should be saved, should be conserved through this kind of process. Agriculture, industry, whatever you say, the efficiency is very poor. National Water Mission is talking about 20% more efficiency, but in reality, it is not happening. Monitoring and implement water allocation of the state plan. The state plan should be prepared by the highest decision-making body, headed by the Chief Minister, and supported by the Water Resource Committee, Planning Committee. Regulate and determine tariff for sewage services, recycling of water, recycling the tariff should be there. Promote universal service obligation because water is a basic human right, and it should be accessed. Protect consumer interest. So the users, water users, should be considered. Promote sound water consumption and management services. Evolve regulation to prevent over exploitation of groundwater. The groundwater and surface water, both the water, are very much important. Frame general principles relating to terms and license. If there is a license, if there is a private service provider, the regulator should recommend to the government the terms and conditions of license, and government can look into that. To advise government in the formulation of policy with respect to the consumer, associate environmental agency to develop policies or regulation to lay safety standard. And the final slide, the consumer advocacy and the redressal mechanism has to be a part of the regulatory activity. There should be power of the regulator to call for information and conduct investigation, because they are the expert body. The regulator can issue direction to the other stakeholders or the service providers, appeal to High Court in certain cases. The regulatory order can be appealed to the High Court in certain cases, or some other agency. There should be chapter on the tariff setting principle. Tariff setting principle is it is not in one word kind of approach. One has to give an example how the tariff setting should be there, which are the areas the tariff should take place. Quality of service, to specify minimum standard of service for supply of water for different use and share services. Settlement of disputes between service provider and the consumer, the stakeholders, and the constitution of the State Resource Committee, which has to be headed by the Chief Minister, and the State Water Resource Council. No, this State Water Resource Committee should be headed by the Chief Secretary, and the other secretaries are members. And the State Water Resource Council should be headed by the Chief Minister, and the functions of the council and the committee be specified. So I want to stop. Faraj. So I want to stop here. Can you go to the? I want to stop here and thank you very much for the patient hearing.
Thank you, sir. Thank you very much for a comprehensive presentation, giving the participants great insight into water regulatory authorities. And also, I think the presentation will be very useful for those states where the constitution of water regulatory authorities is on the anvil. Sir, would you like to make any comments, sir? Chaska, sir.
I want to say that there is a need for a central kind of approach. What should be the regulatory framework in the water sector, and that every state has to position the regulator and they enact the act. Today, in the January meeting of the state secretaries, the central government has told all the states that please enact law and position the water regulator. And particularly wherever the act is there. So there is a direction given by the center, but the point is that how they will proceed, that kind of guidance probably would help in this regard. So this is missing. So model legislation kind of thing is missing. For example, the groundwater bill, model groundwater bill is there, which the state is adopting, and but there is no kind of such kind of bill in our country at this point. So this is a vacuum which I feel.
Yes, sir. Now I would like to invite participants. to if they have any queries or comments to make regarding the presentation, they are free to they can unmute themselves and they can pose their questions or
Sir, I'm D.S. Shaskar, Chief Engineer and Head of National Water Academy. So thank you so much for such a delightful and insightful lecture. It was really enlightening to listen to your views on regulatory authorities, various aspects of water governance. It was really very insightful. Sir, I have a small question. We have a water pricing structure for surface water in most of the states, wherein canal water or river water is charged. But we still do not have a very strong framework for charging the groundwater. Groundwater regulation and groundwater tariff are in a very primitive stage. Sir, what can be done to have a more comprehensive groundwater regulation as well as pricing structure?
You see, the groundwater is used by three kind of group. One is your domestic, one is industry, and one is the irrigation. Now, what is happening is that the many states, there are 21 states and UTs who adopted the model groundwater bill, and they positioned that kind of board, that authority, But in some states, for example, Punjab, they have issued directions on groundwater charging from the industries only. They have not done from the domestic sector side. They have not done from the irrigation side. So these are the missing part. But there has to be, because the water is a finite resource. And the groundwater, depletion of groundwater is happening in many states in the arid zone, semi-arid zone. So I think the groundwater is a subject which is very important from the regulator's point of view as far as the conservation of water is concerned, because this is one of the aspects of the regulator is that they should conserve, they should take steps for conserving the water, and conserving the water means you have to look into three subsectors. So I think there is a need for in many states this is a little missing, because the states thought that that model bill, the groundwater bill, is enough for taking care of the groundwater. But to my understanding, I think the regulator should be given a responsibility in this sector also. That's my view.
Yes, sir. Thank you, sir. Thank you, sir.
Sir, I have one question, sir. Sir, we have, I'm Pradeep Devarmani from Water and Land Management Institute, Karnataka, sir.
Yeah.
We have water tariffs for flow irrigation, sir. Presently, we are implementing micro irrigation. It may be in the form of sprinkler irrigation or drip irrigation, sir. How to fix tariffs for micro irrigation systems, sir?
You see, what happened is that what the Maharashtra has done, they have, when they are irrigating, when they are determining the tariff of the irrigation sector, they are saying that if you are using drip or the micro irrigation sprinkler, then your just a second.
Yes, sir.
Your tariff will be 75% of the applicable tariff. So that means they are encouraging that you should have drip or sprinkler irrigation in the irrigation sector.
Sir, just I need one more clarification, sir. Sir, we are implementing projects of drip irrigation and sprinkler irrigation, sir. We have already implemented in Ramthal, in Singtalur, and in Shigaon lift irrigation scheme, sir. There, government not only supplies water till the field, but even they are providing drip and sprinkler setups for the entire field, sir. So in that context, what should be the water tariff like? That was my question, sir.
No, first of all, you have to find the tariff for the irrigation irrigation sector.
Yes, sir.
You are in a basin. Basin is there. Irrigated portion could be there or may not be there. So
Yes.
that irrigation area, that sector, you have to first determine, set the criteria after discussion with the experts, after discussion with the stakeholders. What could be the tariff for the water in that basin, in the where the basin water is used for irrigation? So the moment
sir.
you have determined the tariff through a consultative process, you can give certain kind of incentive for drip. If it is drip, then you give a, let's say, 50%, 60% or 70%, like that. So that means the first you determine the tariff for the irrigation sector in that basin, then use incentive to determine the tariff for the drip irrigation. That's the kind of.
Fine, sir. Thank you, sir.
If participants have any queries, they can post them by unmuting themselves, or they can even post in the chat box.
I want to make one statement before we conclude.
Yes, sir.
I think to me there is a lot of there is a resistance in the states to position the water regulator in the country. So that one can avoid if there is some kind of political commitment is there. And that political commitment could come if there is a kind of cooperative federalism in the water sector we can think of. Secondly, for this sector, we need some kind of model legislation. And that one could arrive at after a lot of discussion and the kind of consultative approach, etc. And the restructuring of the sector is a prerequisite for positioning regulator. I think this is a very important point. So I think, to my mind, I am just sharing my idea how one can move forward given the current situation.
Thank you, sir. Thank you very much. Sir, we would also like to have the presentation. We would like to share it with all the participants. You can mail it to us. We can still have a few more questions before concluding. If any of the participants would like to ask anything, please make use of this opportunity. Otherwise, we will conclude in a few minutes from now.
Sir, there is a small question. Regulatory authority in water sector has been proposed, I mean, recommended by our national water policy. We are talking about it for the last 2 decades or so. But still, there are only few states, which you can count on figures, who have actually implemented it. And some of them have enacted the laws, but the authorities are not there. So what extra efforts can be done by central government from Government of India to nudge the states to enact the appropriate laws and also to establish the authority? What can be nudging efforts? Can there be some incentivization scheme for the states to implement resources security authorities, or then can be some
Yes, I think
central law?
incentivization scheme will be really welcome, because that will help the states to know, to understand that we have to have position a water regulator. Second is the water is a state subject basically, and since it is a water subject, the commitment of the political machinery in the state has to be there. This is a fundamental thing, and that is possible if the cooperative federalism work in a bigger way. So that probably that kind of process, consultative process. For example, the Ministry of Water Resources, in that, as I was telling you, that the Water Resources Secretaries Conference in January this year.
Yes, sir.
They are the one of the main recommendation is that all states should position water regulator, and all states should have the state water policies. So this implementation of that recommendation, how one can do that, what could be the scheme of things, what could be the documents they are looking for. For example, when you are drawing when you are about to draw a regulatory framework, you look around what is the current one. And if you look at the states, various states, they're all different. There is no conformity. There is no conformity to draw from Saragam. Maharashtra gives an example, but then other states, there are a lot of different. So I think there is a need, there is an urgent need for that kind of approach, model kind of approach, model framework, which is the approval of the central level, state level. I think one can do that.
Thank you, sir. Thank you.
Good afternoon, sir. I'm Krishna. I have one question, sir. What is the private company role or private suppliers role in this context?
Yeah, you see, one of the original objective of independent regulation, what I'm saying in other sectors like electricity, telecom, etc., the regulator is that they should deal with the service provider. Now, the service provider could be government provider, it could be private provider. So in this case, if it is a private provider in a state, then the regulator should recommend to the government what should be the terms and conditions of the service provider. And the government can take a view on that. Secondly, they should also determine what should be the quality of service. And they should also see the consultative approach from the consumer and the stakeholders. So if it is a private service provider, the regulator has a big role to see that the utility, the private service provider, give the service to the satisfaction of the stakeholders with a good quality approach.
Thank you, sir.
Is it okay?
Yes, sir. Thank you for your answer.
Sir, I don't know whether you are able to see the chart box. There are two queries in the chart box.
Can you just repeat it?
I will. Yeah, I can repeat it. One is with reference to the query raised by another participant regarding the micro irrigation. He is asking whether do you mean to say that there should be 50 to 75% of the existing water tariff for micro irrigation.
Yes, what I was saying that the Maharashtra regulator says that if you adopt drip or sprinkler system, then the applicable rate, whatever rate for the irrigation sector is there to provide lift irrigation, because they are determining the lift irrigation, what will be the prices. So out of that 75% for drip. So first the regulator will decide for the lift irrigation, private lift irrigation tariff, and if you adopt the drip irrigation, then it should be 75%. So that is the idea.
Okay.
What is
So
the
there,
question?
yeah, there is one more query. Does relationship that exists between the entitlement and pricing is so strong in implementation? Otherwise, I would like to request the participant.
Can you request him?
Yeah, please unmute yourselves and please be clear in what you want to ask.
Sir, this is Caroline Arul. Am I audible, sir?
Yes,
Yeah.
yes.
Yeah. Sir, I'm an academician working as a teacher. My question is that, no, we are in a state of like having a sort of legal pluralism that is existing in the pricing. I mean, in deciding the water rights. Does this have a connection, when we talk about the pricing of water?
You mean the water crisis and the water pricing?
Yes, sir.
You see, the basic purpose that of pricing is that water is not a free good.
Yes, sir.
If the water is a free good, then people can use it as their own way of doing it. So one of the basic objective of water pricing is that water is not a free good. And if the water is a free good, is not a free good, naturally you will try to save water and consume as low as possible.
Yes, sir.
Look at the domestic sector, look at the industrial sector, look at the irrigation sector.
Yes.
If there is a water crisis, and if you do not have the pricing concept introduced, people will use as their own. So these are two interlinking concepts.
Okay.
Water crisis and the water pricing. Water pricing helps in reducing the crisis in a different way.
Yeah.
Because they guide the domestic sector, industrial sector, that you use water in a less manner. For example, if the industry, if the audit shows that the water use is less, if you do the audit, for example, in Maharashtra, if you use the treated water, recycling treated water, then 60% water is applicable. 60% rate is applicable. So that means that they are giving incentive to the user that if you use the recycled water, then your rate is less. So that means the water pricing and water saving are interlinked actually.
Thank you so much, sir. Thank you.
I think there are no further queries, sir. So we can conclude the session. On behalf of National Water Academy, I thank you very much, sir, for joining us and giving an enlightening session. We would definitely would like to disseminate this with more participants, means those who could not attend the webinar. We would like to share the recording as well as the presentation with all those who have registered for this training program. So once again, sir, I thank you very much on behalf of National Water Academy. And I would like to inform the participants that we will again be meeting at 3 o'clock for the last session on the case study of Maharashtra Water Resources Regulatory Authority by Dr. S.A. Kulkarni, former Secretary, Maharashtra Water Resources Regulatory Authority. We will be meeting at 3 o'clock. Thank you very much for joining us today. Thank you.
Thank you. Thank you very much. Thank you.
Thank you, sir.
Thank you.